So if you were around in the 90s, or honestly, even if you weren't, you almost certainly know the pop culture punchline. A grandmother spilled some hot coffee, sued a massive fast food giant, and supposedly walked away with millions. Jay Leno joked about her, Seinfeld referenced the case. Politicians literally held her up as the ultimate glaring symbol of America's out-of-control lawsuit culture, the classic greedy grandmother who just couldn't handle a hot beverage. But today, in this explainer, we're going to look right past those late-night comedy routines. We're going to uncover the actual legal mechanics, the discovery documents, and the courtroom realities of what is definitely the most mocked lawsuit in American history. Because what you think you know about this case, it's almost certainly wrong. Okay, let's dive into this. To really understand the reality here, we have to immediately strip away that public perception of a trivial, clumsy spill and look at the actual facts of what happened on February 27th, 1992, in Albuquerque, New Mexico. Stella Liebeck was 79 years old. Now, the prevailing myth is that she was driving down the highway with a cup of coffee clamped between her knees. That is entirely false. She was actually a passenger in her grandson's car. The car was completely stationary, safely parked in the McDonald's lot. She placed the cup between her knees simply to pull off the lid and add some cream and sugar. When that lid came off, the coffee spilled. And what happened next was not just some minor discomfort. Section 1, the punchline versus reality. The reality of this incident was an absolute severe medical emergency. You know, this wasn't the kind of spill where you just grab a napkin, wipe off your jeans, and go about your day. The medical photographs entered into evidence during the trial showed horrific injuries. Stella was hospitalized for 8 grueling days. She had to undergo really painful skin grafting surgeries and spent 3 entire weeks in intense wound care treatment. She suffered third-degree burns. And just as a reminder, that is the most severe classification, burning completely through all layers of her skin right down to the subcutaneous tissue. These burns covered 6% of her body, specifically her inner thighs, groin, and buttocks. She even lost 20 pounds during recovery. And frankly, that's a physical toll a 79-year-old simply cannot afford to take. And the financial toll completely matched the physical one. Her medical bills for those skin grafts and the hospital stay reached nearly $11,000. Now, remember that myth of the greedy millionaire seeking a massive payout? Yeah, that's not how this started at all. Before ever filing a lawsuit, Stella wrote a letter to McDonald's. She wasn't asking for millions of dollars. She simply asked them for $20,000. That amount was calculated purely to cover her medical costs and the lost wages of her daughter, who actually had to take weeks off work to care for her mom during the recovery. It was just a very straightforward request to be made whole after a totally devastating injury. And this brilliantly illustrates the real turning point of the entire story. McDonald's received her request for $20,000 to cover legitimate medical expenses, and they countered with a staggering offer of just $800. I mean, really think about that disparity. An $800 settlement offer for a woman who just spent 8 days in the hospital undergoing skin grafts because of their product. This aggressively low offer effectively left Stella with absolutely no choice. To cover her mounting medical debts, she was literally forced to hire a lawyer and file a formal lawsuit. Section 2. Proving corporate negligence. When that lawsuit was filed, the case moved into the discovery phase. From a legal perspective, this is where our focus shifts entirely to the concept of negligence. Discovery is the legal process where a corporation is forced to hand over their internal documents and communications. It's like a giant puzzle where we find out not just what happened, but what the company actually knew beforehand. And let me tell you, what was uncovered in McDonald's files transformed this from a simple personal injury claim into a deeply disturbing look at corporate policy. Notice the stark temperature difference here. This is absolutely crucial to the legal argument of negligence. Your typical home coffee maker brews at around 135 to 140 degrees Fahrenheit. Most modern coffee shops serve their drinks at 155 to 165 degrees. But McDonald's? They had a strict, deliberate corporate policy requiring their coffee to be served between 180 and 190 degrees. At that extreme temperature, liquid causes a full-thickness third-degree burn in just 2 to 7 seconds of contact with human skin. So why do this? Well, in court, McDonald's argued customers wanted it hot for their commute, but internal documents suggested it was a cost-saving measure. The extreme heat allowed them to use less coffee per cup while still maintaining a perceived strong flavor. But the negligence argument really hinged on whether McDonald's actually knew this policy was dangerous. And during the trial, McDonald's own quality assurance manager, Christopher Appleton, took the stand and provided the answer. He testified that the company had received over 700 complaints about burn injuries from its coffee in the decade prior to Stella's spill. 700 complaints. Some of these involved third-degree burns. Some of these victims were children. The corporation was fully 100% aware that their product, served at their mandated temperature, was causing severe harm. Yet they did nothing. There was no temperature reduction, no safer cups, just a tiny warning printed on the side. Which brings us to one of the most remarkable pieces of evidence in the entire trial, the corporate cost-benefit analysis. McDonald's internal analysis had actually calculated that the number of burn lawsuits they would face was an acceptable cost compared to the immense expense of overhauling their coffee policy nationwide. In corporate legal strategy, this is quite literally a cost-benefit analysis of human injury. They impartially ran the numbers and decided that paying off burned customers was simply cheaper than fixing the underlying nationwide problem. When this document, proving they calculated human injury as a cheaper alternative to safety, was entered into evidence, it fundamentally shifted the tone of the trial. Section 3. The jury sends a message. We definitely see the result of that evidence when we look at how the trial concluded. The jury was presented with the severe injuries, the 700 prior complaints, and that cold cost-benefit analysis. In later interviews, jurors explicitly stated that McDonald's attitude throughout the trial was just dismissive and unbothered. The internal documents proved to the jury that the corporation was largely indifferent to customer safety. Angered by this corporate attitude, the jury decided it was their legal duty to send a clear, unmistakable message through their verdict. Now, what's really interesting about this slide is how the jury actually approached the compensatory damages. They didn't completely absolve Stella. Under the legal principle of comparative negligence, they assigned 20% of the fault to her for how she handled the cut between her knees. But they assigned 80% of the fault to McDonald's for serving a dangerously defective product. Because of this, her original $200,000 compensatory damage award, which was meant to cover her pain, suffering, and medical bills, was legally reduced to $160,000. This really shows that the jury was actually incredibly thoughtful and measured in their initial calculations. But compensatory damages are really only half the story. The jury also awarded punitive damages. In our legal system, these are not designed to compensate the victim. They are financial awards specifically calculated to punish a defendant for outrageous conduct or deliberate negligence, and to deter them from ever doing it again. This is a super critical legal distinction. The millions awarded in this phase were absolutely not meant to enrich Stella Liebeck. They were a targeted legal penalty against a corporation that knowingly ignored 700 burn victims just because it was cheaper to do so. So how did the jury arrive at that famous $2.7 million figure? It wasn't just some random lottery number pulled out of thin air. The jury deliberately calculated that $2.7 million was equal to exactly 2 days of McDonald's coffee sales revenue nationwide. They wanted a penalty that would genuinely make a multi-billion-dollar corporation feel a financial sting. However, the legal system has checks and balances. A judge later reduced this punitive award heavily to $480,000. Both sides eventually appealed, and they ultimately settled out of court for an undisclosed amount, almost certainly less than $600,000 in total. Stella never became a millionaire. She passed away in 2004 at the age of 91, largely remembered by the public as a joke. Section 4. The tort reform machine. But how did she become a joke? To understand that, we really have to shift our focus to the macro legal view and examine what happened after the verdict. The aftermath of this specific case was quickly seized upon and handled by a very powerful network of corporate lobbying groups. The mockery of Stella Liebeck didn't just happen organically around water coolers. It was manufactured by industries with a highly specific legislative agenda. And that agenda was called tort reform. In the legal world, tort reform represents legislative efforts aimed at capping the damages individuals can win in these types of lawsuits. In the early 90s, groups that were heavily funded by major manufacturers, insurance companies, and fast food chains like the American Tort Reform Association were pushing hard for these caps. But to win over the public, these groups needed a symbol. They needed a story that would make average Americans question personal injury lawsuits altogether.
Let's move to and see how this builds a highly strategic communications campaign. According to legal scholar Valerie Hans, who studies jury decision-making, lobbying groups basically weaponized the case before all the facts were even public. Her research shows exactly how they pushed a narrative to talk shows and editorial pages that intentionally stripped out the 700 prior complaints. They completely ignored the horrific third-degree burns. They entirely erased the internal cost-benefit memo from the public conversation. They left behind only a clumsy old woman and a ridiculous lawsuit. According to this research, it was a completely manufactured myth designed to turn everyday Americans against the legal mechanics of personal injury claims.
And you know what? This PR campaign was wildly successful.
Following the 1994 verdict, the mockery dominated the mid-90s. And from the late 90s onward, numerous states successfully passed tort reform legislation. These new laws explicitly capped punitive damages. The very tool the jury used to punish McDonald's for ignoring 700 warnings was systematically weakened state by state. So while late-night television kept playing the coffee clip for laughs, the ability of everyday citizens to hold corporations financially accountable for deliberate negligence was being quietly dismantled.
Section 5, Your Rights Today. Which brings our explainer right back to you, the viewer. What is the practical application of this weakened legal system today? Stella Liebig was arguably the last famous example of the personal injury system working exactly as designed, an ordinary citizen harmed by corporate negligence receiving actual justice from a jury of her peers. Today, because of the tort reform movement that basically used her as a punchline, navigating corporate negligence requires extreme vigilance. So the crucial point is knowing how to protect yourself if you ever find yourself in a similar situation. If you are ever injured by a product or a corporation, you must document everything immediately. Photograph your injuries extensively, just exactly as Stella's team did. Keep every single medical record and write down every conversation. And perhaps most importantly, do not accept the first settlement offer. Remember, McDonald's initially offered just $800 for weeks of hospitalization and serious skin grafts. I really want to leave you with this final thought. In states that successfully passed tort reform and enacted strict punitive damage caps, the legal landscape has fundamentally changed forever. A corporation can now harm thousands of people and calculate in advance exactly the maximum penalty it will cost them, because the law legally dictates the cap. If a corporation knows the exact maximum price of your injury before it even happens and can simply budget for it as a routine cost of doing business, are you really protected? It's a profound legal question that we are all still grappling with, decades after the world laughed at Stella Liebig.